Introducing My Hoover. Through this new feature, you can now more easily follow the work of your favorite fellows and policy topics. Customize your newsfeed, manage newsletter subscriptions, and receive notifications when your favorite publications, broadcasts, and podcasts go live. Bookmark articles, essays, and multimedia for later viewing. Take the step to create a My Hoover account now and transform the way in which you acquire this valuable knowledge.
Between now and the spring, the Supreme Court will rule on at least 3 cases involving Donald J. Trump. 2 questions. What should the court rule, and what will it rule? Richard Epstein and John Yoo on Uncommon Knowledge now. Welcome to Uncommon Knowledge. I'm Peter Robinson. Richard Epstein is a professor of law at New York University, a professor of law emeritus and a senior lecturer at the University of Chicago, and a fellow here at the Hoover Institution. John Yoo is a professor at the University of California, Berkeley Law School, and like Professor Epstein, is a fellow here at the Hoover Institution. Professor Yoo served as Deputy Assistant U.S. Attorney General in the Office of Legal Counsel during the administration of President George W. Bush. I should note that Richard and John are old friends, having appeared together for more than a decade now on Law Talk, the Hoover Institution podcast. Much of the time they agree, but when they disagree, it is King Kong and Godzilla.
I'm Godzilla.
I was wondering.
He's King Kong.
Okay.
I'm Fay Ray.
All right, boys, will you pipe down now? Each one of these requires a bit of a setup. I have to explain the case, but then off you go. Trump versus Anderson. Here's the background. Last December, the Colorado Supreme Court ordered former President Trump's name removed from the ballot of the Colorado Republican Party, which will hold its primary election this coming spring. The basis for that ruling, the events of January 6, 2021, the Colorado Supreme Court held A, that Trump's actions before and during the attack on the Capitol amounted to insurrection against the United States, and B, that the 14th Amendment, this is the amendment ratified in 1868, that the 14th Amendment disqualifies anyone who has engaged in an insurrection against the United States from running for president. Donald Trump appealed the Colorado Supreme Court's decision to the United States Supreme Court, and as we sit here, just last week, the court announced that it would take the case. We're recording this program in mid-January. The court will hear oral arguments on February 8th. Former federal judge Michael Luttig, long considered a leading conservative and originalist, quote, Section 3 of the 14th Amendment simply could not be any clearer that the former president is disqualified from the presidency, just as the Colorado Supreme Court held. John Yoo?
What?
What should the court rule? Is Luttig right? Is this
wrong.
A slam dunk?
No, this is not a slam dunk. It's a close case. In fact, 2 very distinguished originalist scholars were the ones who came up with this idea that you could disqualify a president under the 14th Amendment, Section 3, which is written right after the Civil War, and of course is primarily aimed at the people who joined the Confederacy, but not limited to the people who joined the Confederacy. I think that the U.S. Supreme Court will quickly overturn Colorado. I think we're going to see light speed in terms of how fast that opinion comes out for several reasons. One, I don't think that the founders, the people who wrote the 14th Amendment, and I certainly don't think the Supreme Court will think that there should be 50 different states all interpreting the 14th Amendment differently, all applying their own standards.
Since this Colorado Supreme Court decision, the Maine Secretary of State took it on herself to kick Trump off the ballot. So this is...
And you've got 3 other state Supreme Courts saying, no, Trump isn't disqualified.
Including
under
California,
the ballot.
by the way.
Mm-hmm.
Yes.
California's Secretary of State. So if you think about what the kind of disorder and chaos that could arise if each state is allowed to say, we're going to choose our own disqualification standards and we're going to start kicking people off the ballot. It's also not just the president you're talking about. You're talking about people who run for Congress, for Senate, members of state houses. The list of officials this provision applies along. So that's what the second thing is. I don't think the provision applies to the president. It doesn't say the word president. It doesn't seem to apply to people who were president, who might have engaged in an insurrection, and it doesn't seem to prohibit people from running for president. So I think there's really two strong grounds that the Supreme Court
But one of them is
can
pure
use.
policy prescription. I'm forced to point out, Professor Yu.
Policy.
You're saying that the Supreme Court won't permit this to stand because it wouldn't work well.
Well,
that's
but
not a legal argument
No,
at
no,
all.
but that's a legal argument because that is one of the reasons why you have a single Supreme Court to impose a uniform interpretation of the Constitution throughout the country.
Okay, I'm coming to you in just a second, Richard, but first listen to this. Adam Liptak in the New York Times. The point here is that this case is even bigger than it sounds. Quote, "The sweep of the court's ruling is likely to be broad. It will probably resolve not only whether Mr. Trump may appear on the Colorado primary ballot, but his eligibility to run in the general election and to hold office at all." Close quote. We have a number of polls over the last few months in which Donald Trump leads Joe Biden. Yeah, I just looked at a poll, ActiVote poll, the other day where Trump leads Biden by 8 points. Now there are other polls, but in some polls he's leading. Is it conceivable that the Supreme Court could choose to tell Trump voters in their tens of millions that the final decision about whether Donald Trump may or may not run for president sits with the court and not with them?
No, it's not conceivable.
It's not.
The question is how you reverse this situation. And there are many grounds that you could use, but there's only one that works. What you must do is to simply say that this is an issue which is a political question and the courts have nothing to do with it. Let me sort of elaborate on some of the things that John said. Right. You misstated the problem when you gave it to us. You committed legal malpractice.
Well, it's not the first time.
Nor is it the last time.
and not for the last time. I'm thinking to myself, not for the first time, I'm thinking to myself, thank goodness I don't get a grade from Richard at the end of this.
Well, I mean, but what happened?
He has a grade for you, he's just not telling you what it is.
Well, no, but this is a common mistake.
All right.
What that you just said is that it disqualifies any person from president for an insurrection, right?
Right.
That's not the way the amendment reads.
But that's what the Colorado Supreme Court
I know,
held.
but they made a very serious mistake.
Well, at least
I mean, what you do is you have to start with the beginning of the provision, which says when you're talking about a senator or a representative or a presidential elector, they are going to be subject to this. And then there's
And that's clear in the language of the
yes,
amendment.
that's what they say. They don't mention the president, but they mention the presidential electors. So the first question you want to ask, is this just an omission that somehow they didn't think of it? No. What they were trying to do is to make sure that any state official coming from the South would not be corrupted by the various sorts of insurrection. So what they did is they went after the members of the Electoral College because those are chosen on the state level. And if it turns out you get all of the insurrectionists or rebellion people out of the thing, then when you run the Electoral College, you have the right bunch of people and they will make the right kind of decision.
They didn't want a bunch of former Confederate officers
determining who would
in
be
the
the
Electoral College choosing the next president.
But if they're not
what it
there,
comes down
yes.
to?
And if they're not there, then you have a perfectly normal Electoral College and you let the political provisions go. Ludig is very irresponsible on this because they never take these words into account. So that's a first problem. The second thing is there is a very technical decision that is hinted at by John, is there's one thing to talk about the president having an officer, and there's another thing to talking about the president being an officer. Office versus officer. The R makes all
Office
the
versus officer.
Yes,
All right.
the R makes all the difference because if you then look at the Appointments Clause of the Constitution, it says that all people who are appointed as officers have to be appointed by the president. And so what you do is you're saying if the president is an officer covered by this clause, it means that the way he gets chosen is in fact to appoint himself as president. And so what Michael Mukasey said some time ago is...
Michael Mukasey, former attorney general, and a very fine lawyer.
What he said is that, look, he said, if you look at the remedial provision, Congress has the veto power that it can waive. 2/3 of the people say you could do that. And what it clearly is, this is about appointive officers because that mechanism could not possibly work for the president who's chosen through a very different system on the Electoral College.
So the court will say, we want nothing to do with this.
And
it will decide it on such narrow grounds that it will come down to the letter R.
Well, and now we won't come down to that. There are lots of other things, but yes, it's an important...
But they'll choose the narrowest ground possible because the Chief Justice wants everybody on board, correct?
Hopefully it would be a unanimous decision. I don't expect it would be, but that would be ideal. And this would be, in a way, democracy enforcing because then Trump stays on the ballot and the people can decide. The one thing about going the other way, and I agree that I can't see the court upholding Colorado because it wouldn't just be upholding Colorado. For it to uphold Colorado,
Every
the
other
Supreme
state.
Court, the Supreme
He
Court have to
takes them
say,
off.
not only is this something we can decide, not only does this apply to the president, but we also have to find Trump engaged in an insurrection on January 6th. And so the Supreme Court would actually remove Trump from the ballot in all 50 states.
Yes. That's
I
lip
can't see
text
that
in the New York
happening.
Times.
Yes,
Yeah, I
and
can't see that happening.
It's not going to happen.
All right, and you said you expect a decision with lightning speed.
Yes.
Colorado holds its primary. The Republican Party in Colorado holds its primary on March 5th, which is Super Tuesday. It's a big day in the electoral.
Yeah, but what
count. You think we'll
happened-
have a decision by then?
Yeah,
They'll be
absolutely.
hearing oral arguments
I mean,
on February 8th.
Look, this is either you will or you won't. But what the Supreme Court will surely do is to say you have to have two ballots. He's on one and he's not on the other if we can't decide the case before then. It's a very small alteration, but you can't possibly let the system run under the current situation. And then the Supreme Court says that the Colorado court is completely misguided. So they're going to have to make at least some adjustment. But then on the question of what's an insurrection, their definition is one of sheer madness. What they said, in effect, if you have two or more individuals,
They, meaning
in
the
the Colorado
Supreme
Supreme Court, the
Court.
four in the majority, right?
Right.
Two or more individuals who threaten or use force in order to determine the outcome of an election is engaged in essentially an insurrection. That means every time you had somebody in the Jim Crow era blocking black people from voting to change the outcome, it was an insurrection.
Under this definition, Peter, you've been an insurrectionist almost every 4
No,
years,
no.
going back a half century.
Yeah, but it's just crazy. You look at real serious insurrections. I mean, for example, I've been studying the Spanish-American War and insurrections lately. Don't ask why, but it doesn't matter. And it
Separate
turns
show. All right,
a separate show. But what you do is you have a situation where we conquer the Philippines, take it away from the Spanish, and there was a full-scale insurrection out in the mountains with generals and soldiers and everybody fighting. And so what happened, what McKinley said is, I'm going to tell my Secretary of War, Elihu Root, put down this insurrection. That's an insurrection. This is at most a riot. And it's not even that. This is
By the way,
basically...
can I also ask, just as a mind legal knowledge goes back to Dartmouth College quite some time ago, but isn't
Which
it a
doesn't have a
basic...
law school, so how'd you get in?
Well, there was a great constitutional lawyer who taught con law at Dartmouth, even if it
You studied with Daniel Webster?
Almost.
You look like it.
Almost.
It's a little college, but those of us who've been there love it.
All right. Okay. Thank you very much. Enough of that. But the notion is that juries are finders of fact. This question of whether Donald Trump engaged in an insurrection has never been before a jury.
You put your finger on a really important legal issue,
That was the
which also
dissent.
the court can use to escape.
This professor
Yeah,
likes
no,
me.
no,
There's
which
one.
is that
Go ahead.
the court could say the 14th Amendment, Section 3, does disqualify certain people for being involved with an insurrection, but it's up to Congress to implement it. When Richard just said, oh, the Colorado Supreme Court just made up its own definition of insurrection.
It certainly
applied
did.
And applied to the facts of the case without ever having a trial where Donald Trump could appear and get due process and right to counsel, all the jury trial.
Yes.
So an important way that the court could, I think, escape having to make a decision is say, it's related to Richard's political question point is, this amendment is still good, it's on the books, and it's up to Congress to define what's an insurrection. It's up to Congress to decide how you prove it, and so on. And until Congress does that, we, the courts, have to stay out. That's not a very dangerous thing to say. In fact, that's something the court regularly says when it comes to other provisions in the Constitution. It has to be executed by Congress first. And so then your point is going, Peter, there is an insurrection statute that Congress has passed. Donald Trump has not been charged with it. Despite President Biden's speech kicking off his campaign where he accused Trump of being an insurrectionist, where he accused Trump of attacking democracy, his Justice Department has not charged Trump with insurrection, even though there's a statute sitting out there. In fact, the only word we've had from any body of the federal government, whether Trump committed insurrection, is that he was acquitted of insurrection in the second impeachment trial. That's the only definitive word out there
They
right
did
now.
use the word in one of the articles of impeachment.
Right, incitement to insurrection. He was impeached for that by the House, and the Senate did not convict him on it.
On to the immunity case. May I
Yes.
go on to the second case?
You do whatever you want.
All right.
It's a
all
free
right.
country.
No, I just see that. I can see that you want to start telling us about the Spanish-American
No,
War.
I don't. I wanted to make this
I've got to
one
head
little-
that one off right
No,
away.
I'm not going to. I'll just make
By the
one
way, when
little
you
point.
No, okay. Make
when
the
you
point,
have
make
him
the
on
point.
for that
Oh,
show, I don't want to come. You can
One
talk
of the
about
one of the
that little
things
war
about
on
it,
your
if
own.
what you're doing is talking about removal from office, it need not be a jury trial. It could be a trial in equity, which does not require juries. So what John is right is essentially there are no procedures that are done in this particular case that are uniform. And so what he's doing is a very clever move, saying Congress has to do this, and if Congress doesn't do it, then all the states are immobilized. The key point here is what the end result is. You need to get complete immobilization. This thing has to be out. So you can't say, oh, Colorado was premature. They have to wait until T was put on the presidential ballot before you can remove him. That would be a disaster.
Okay. So they have, all right.
Before you move, I just have to,
Yeah.
one moment disclosure. I'm probably going to write an amicus brief at the court on this case. That's why I've been thinking about it a lot. So I just want to disclose that so it doesn't look
Well,
like
I mean, do you want to
secretly
if you'd like to make notes as we talk,
No.
if anything I say strikes you as worthy of the
Well, you
justice's
keep writing
attention.
that brief and I'll
Oh,
sign
I'm
it.
quoting you in the first paragraph now, Peter. You're in big trouble.
So what's the next immunity
Okay,
case?
the immunity case. This one is not before the Supreme Court yet, but it will be. Here's the background, and again, bear with me. I'm going to set it up and then hand it to you. Justice Department Special Counsel Jack Smith wants to prosecute former President Trump for, and here I'm going to quote a document written by Smith's team, for, quote, unprecedented effort to retain power through criminal means despite having lost the election, close quote. There's an indictment against Trump. It includes 4 charges. By the way, insurrection, as you're quite right, is not one of the charges. Trump's lawyers claim that his actions were covered by presidential immunity, and the Supreme Court has indeed ruled that former presidents are immune from prosecution for official actions even within a term from the court, the outer perimeter of their official actions. Judge Tanya Chutkan, a district judge in the District of Columbia, rejected Trump's claim of immunity. Special counsel Jack Smith then, in a very unusual move, asked the Supreme Court to take the case and rule on it immediately, bypassing the U.S. Court of Appeals for the District of Columbia. The Supreme Court said nothing doing, with the result that the case is now before the U.S. Court of Appeals, which heard oral arguments earlier this very week. Why am I mentioning this when we're talking about Donald Trump before the Supreme Court? Because whoever loses in the Court of Appeals is certainly going to appeal to the Supreme Court. As I say, the Court of Appeals in the District of Columbia heard oral arguments earlier this week. Here's a brief excerpt.
Could a president order SEAL Team 6 to assassinate a political rival? That's an official act in order to SEAL Team 6?
He would have to be and would speedily be, impeached and convicted before the criminal prosecution.
What if he weren't? There would be no criminal prosecution, no criminal liability for that?
Chief Justice's opinion in Marbury against Madison and our constitutional tradition and the plain language of the impeachment judgment clause all clearly presuppose that what the founders were concerned about was not.
I asked you a yes or no question. Could a president who ordered SEAL Team 6 to assassinate a political rival who was not impeached, would he be subject to criminal prosecution?
If he were impeached and convicted first. And
so your answer is no.
My answer is qualified yes.
All right. So presidential immunity. The judge is presenting one hypothetical after another. She ends up with that very dramatic hypothetical. And Trump's lawyer had some trouble with it, as far as I could tell.
He'd had big trouble with it.
Okay. So,
but the first thing I would do if I were Trump's lawyer is I would say, in this particular case, what happens is we are dealing with situations in which he is not president as well as based situations with president. And I think the right answer for him to make is, in this particular case, he's not acting within his official powers, so we don't have to worry about the hypothetical. And the moment he says that, he's doomed. So that what really happens is he loses this case no matter what answer he gives to that question.
To that hypothetical.
The hypothetical, because he's not in, this is not about official acts. And the argument is, as they said in an earlier case, so long as you are dealing with a situation in which he's running for office and trying to get it, he's not within the outer perimeter of his official duties. That's the ground on which he should lose. This would be an extra thing. But if you take this issue up, this is the way you treat it. Sure, you could prosecute the president. Why is that? Well, where do you get presidential immunity from in the first place, Mr. Trump? Well, the answer is you don't find it in the text of the Constitution because it's just not there. It's a judicial doctrine. Now, we want it, generally speaking, to be an absolute doctrine because if it's based on a qualified immunity, i.e. based on malice, you could sue the president for everything every time. But the way in which you put it is that we created this doctrine out of whole cloth because we needed it.
The courts.
We, the court, because we needed to keep separation of powers in order. But we will make an exception to that in cases in which there's been a dire emergency created by a flagrantly illegal act. And one of the judges in this case had a real zinger of a line. She said, look, the president's job is to take care that the laws be faithfully executed. You're telling me he's going to get an immunity when he commits an act which is designed to make sure that these laws will be unfaithfully disregarded? Can't do that. So the answer he should say is, yes, he can be prosecuted under these situations because the immunity that was given under the Constitution by judicial interpretation can be limited by judicial interpretation.
John?
I don't think that President Trump has immunity from criminal prosecution. I don't think presidents have this kind of immunity that Trump is seeking. What Trump is trying to do is just delay the start of his trial in Washington, D.C. as long as possible so it doesn't affect the election. I think this is a real loser argument, but they've identified this area where the Supreme Court has never said anything because we've never had a president prosecuted before by the federal government, so it's never come up. If you really want to get
that, this is the first attempt at a criminal prosecution of a former president in the history of the Republic.
For acts done while he was president.
For acts committed while he was
So why
president. All right.
would you ever have to face an immunity question? So there's no Supreme Court case that clearly addresses this. You can make inferences from various opinions of the kind that Richard are talking about, and if you took those inferences properly, I think the lower courts have been correct here, actually, or they've said there's no criminal. I don't even think it's a close question. But the reason why there's still important constitutional.
So the Court of Appeals is going to uphold Judge. I'm sure I'm mispronouncing.
Judge
Chutkan. Thank you. The Court of Appeals will uphold Judge Chutkan, who said yes, the prosecution may go forward, and the Supreme Court will then uphold the Court of Appeals.
No. It's not quite correct.
I actually think that's
because
right.
what happens is there's the double jeopardy issue, and that's a much closer question.
What double jeopardy issue?
The double jeopardy issue that's been raised, of course, and was judged by Judge Chutkan, is that Trump had gone through an impeachment trial. He had been acquitted in that particular trial. It was a criminal offense. And so any event that could have been prosecuted in that January 6th trial is going to be covered by double jeopardy. And if he had been convicted, there's a procedure which says how further punishment is going to be done after he's out of office. But there's nothing that says what happens when he's acquitted.
He's going to lose that one, too.
I think he should. That one I think he should win.
Really?
Yes, I do, because I think it's right.
Hold on. I just want to be very. So we have the presidential immunity. The courts made that up because they needed to make it up to keep separation of powers in order. Got it. Trump's team is claiming too much. John says they know they're claiming too much. This is just a delaying action. But then there is a totally separate question in the same case. Somebody give me just a brief definition of double jeopardy.
This is actually wrapped up in the immunity question in terms of Trump's arguments, but it's not the right place. In fact, there's a lot of arguments that Trump can make, but they're in the wrong place, which is this issue. But the claim that Trump is making is, I was already tried for this. I was impeached by the House in the second impeachment trial for incitement and insurrection, and I was acquitted by the Senate. That's, according to Richard, like an earlier criminal case. And there's a clause in the Constitution against what's called the double jeopardy clause, which prevents the government
That's a
from
principle
trying
in
you
common
twice.
law.
No, it's also, common law, less so.
Oh, okay.
I
All
mean,
right.
Can I just say why I disagree with Richard is because the founders, I think, made quite clear that impeachment is not a criminal proceeding. It is just a proceeding on whether to remove someone as president. Then there's something called the criminal law, which is about trying someone and putting them in jail for things they've done. And I think the founders thought those were two separate, totally separate procedures.
I disagree. This is called you convicted, and it says of a high crime or misdemeanor, right, and bribery. So those are all criminal offenses. So I think this is a criminal trial. What happens is...
And the DOJ drew up its list of charges in a manner that makes them too close to...
Yes. To this, because you see what happens is double jeopardy has a very subtle situation. Suppose you have a single event like J6, and there's 6 different offenses you could put: A, B, C, D, E, and F. And what you do is you only charge A, B, and C, and the guy is acquitted. Then they say, oh, we could come back and go after D, E, and F. Well, at that point, you could slice this cause of action into an infinite number of cases and destroy the presidency. But this is not a civil proceeding. This is a criminal proceeding. It says punishment shall go no farther than removal from office, and there's no double jeopardy protection in the case of a conviction because you're supposed to be tried criminally for everything else. But if there's an acquittal, That's the same thing as an acquittal in an ordinary criminal trial. What it doesn't do is protect them for anything that goes on in Georgia, but it certainly protects them from everything that goes on there. I read Chutkan's opinion. I thought it was very weak on that point. And, you know, why they raised the
Court of
immunity.
Appeals is going to be better on that point?
Who knows? I mean, as John says, this is terra incognita.
Isn't the Court of Appeals generally considered the second most important
Yes,
court?
it is.
Generally,
So we'd have talent on that
Oh,
court.
generally the D.C. Circuit is a better court than the Supreme
Well,
Court.
don't say that.
It is. No, I mean
No.
the judge. Now a lot of the judges on the
clerks
Supreme
are Larry
Court came
Silverman.
from there. No, but like Bork, Scalia, I mean, you know,
Right,
Ginsburg,
right.
they all came from the D.C. Circuit.
Okay,
I
so
think,
two
yeah.
questions then.
Yeah.
We know how you think the court should rule. Trump's immunity claims should be struck down.
They will be.
Or refused. But we have a split decision right here. I mean, we just have the two of you and you're coming up with a split decision on the double jeopardy
Yeah,
business.
I think John's wrong.
So here's my further question. The further question is, John made the point that everybody knows, including Donald Trump's team, that this is a delaying action. Are courts permitted to take that into account? Are they going to move with extra dispatch because they
No,
don't want to be
because-
used in this way?
Because this is true in every criminal case that's ever been brought.
All right.
So what happens is now this is a situation. Look, the real abuse in this case was Jack Smith going to the Supreme Court and asking them to circumvent standard processes in order to get an early date.
But Jack Smith had an argument, or at least
No, he had no
Yeah,
argument.
he had actually no reason.
No
why it
reason
had to
why he
be
said-
Well, the
accelerated.
reason is because
This
we're
case is
facing
very-
a presidential election. Whether this man is guilty of these charges or not is material information that voters ought to have before they cast their
But
ballots.
that's not something the
No,
courts
it's
should
supposed
take
to
into
take
account when
and-
they schedule trials. This is actually a problem that's not just created by Jack Smith, it's also created by Judge Chutkan. Because
Yeah.
they set an irrationally
There's
fast
an early
date for
date.
the trial to start. The day before Super Tuesday, because they obviously want the
She
trial
lost.
done before the elections really get going, the nominating conventions. But this is really, I think, taking away Donald Trump's right to put up a full and fair defense. I mean, this is
I-
such a complicated case.
Case.
Think of all the witnesses and facts. We can't even agree on all the initial legal issues. How's that all going to be fairly put together, litigated, and sent up to the courts and come back and forth and have a full and fair trial? I can't see how this could be done
And it's even
this
worse.
year.
See, John is being kind. It's even worse than that. Suppose you were
John
able
is so seldom kind that he doesn't
Yeah,
matter
like,
the
I'm
IC.
laughing at the
John
idea
is
of it.
right. Suppose John is right,
You're-
and
you're-
this thing is now solved by June
killing
of
my
this coming year.
reputation.
Is that going to end the public debate? What's going to happen is all the Trump supporters will say, "This is even horrible. Look what they did. They absolutely manhandled this guy," and they will go through the proceedings. You will solve nothing by getting a verdict, because not only will you have the public criticism, probably rightly done, but you'll also get a repeal on that. And so what our friend Smith said, I get a conviction on this case. It's going up on appeal. I want the conviction to be weighted by the jurors, and they don't have time to hear about the appeal. This is absolutely crazy to interact these two kinds of things. Totally irresponsible by Smith. He's a hack. Remember, he was the guy who...
Whoa.
He was
All the press, I mean, half the press says this man is he's an aggressive but meticulous prosecutor.
Hack's too strong. He's overly aggressive and has already lost 9-0 at the Supreme
Yes,
Court
with
in
McConnell
earlier
ca-
cases, but
And-
he's just overly aggressive
No,
and not really. I
and
actually
all-
think lacks political good judgment. Because the best thing for our system would be for there to be an election, and then we have the Trump trial.
Now he's
after the
this is the
election.
second act of kindness I've seen
No,
John
but
engage in.
That
the
would be
problem
ideal
is
from
you
John
can't-
Roberts'
Yeah, but you
perspective.
can't have a trial of Trump when he's a sitting president.
It would have to be
I
delayed.
mean, my view is you shouldn't even take in the deposition in the civil case of Bill Clinton with Paula Gomes when you have a God president there. Remember what it did?
Oh, well,
is
you
it
lost
led-
on that one, Richard.
I know I lost. And there was
Unanimously at the Supreme Court.
Which I thought they were terrible. I won't use the word hack, but one of the things I will say is any trial lawyer, and I've done a little of this kind of stuff, knows that depositions are every bit as dangerous and maybe even more so than trials. Because you say something there, you can't take it back, and then all of a sudden it's the basis of an impeachment case. So what you do is you suspend all the proceedings, get rid of the statute of limitations, preserve all the documents and so forth, but try it later. And the reason that Smith is so wrong, I mean, he has such an absolute crazy view of this particular case on its facts, and he wants to assume that what he says in a complaint is necessarily true so that a conviction follows. But he's going to be contested on every single point that he makes, including whether or not Trump believed what he said, where he's crazy enough to believe what he said.
All right.
Yeah, if I were If I wanted to use the criminal justice system to punish Trump, I would still be unhappy with the way Jack Smith has done. He's really screwed the case up. The charges, think of the charges. He's charged them with defrauding the government in a statute that's usually used against government contractors and hospitals. He's accused Trump of interfering with a congressional process, which is a statute that's usually used for people who destroy evidence in congressional hearings.
Right, we're coming to that one in a moment.
And then defrauding every voter of the United States of their right to. So none of these charges actually fit the crime. He could easily lose in the courts on all of them. In fact, the Supreme Court has already granted cert on that middle charge because that's the main charge against most of the January 6th protesters.
All right.
And the court, in the previous cases, has said you prosecutors should be limited and humble in how you use that statute. You're overcharging it. I could easily
Stop
see.
there. Stop.
Sorry.
Stop. Don't stop. Put
Don
a pin
is
in
right
it.
on this
No,
one.
no, stop. No, because this is the third case I want to discuss. And you're denying me my big moment.
go
to
ahead.
set it up.
Oh, you want to set it up?
I
You want
to
due
set it up.
process rights?
I would like our viewers to have some idea what you were talking about.
You can see what it would be like if Richard was a trial lawyer. He'd be
yes.
like the trial lawyer from hell. He would destroy you as a
You
deponent.
have produced one of the great lines of all time that if Richard occupied all 9 seats on the Supreme Court, there would still be a lot of 5-4 decisions.
He doesn't really get that joke, but
All right,
everyone else does.
Fisher versus the United States. Joseph Fisher participated in the riot at the U.S. Capitol on January 6, 2021. He was charged with obstruction of an official action under the Sarbanes-Oxley Act of 2002. Sarbanes-Oxley was intended to deal with white-collar crime. That being said, prosecutors have used Sarbanes-Oxley in charging more than 1,000 rioters such as Joseph Fisher. I believe the number of rioters who've been convicted on a Sarbanes-Oxley charge is over 800. To quote one plaintiff lawyer, the statute, that's Sarbanes-Oxley, has been used to over-criminalize January 6th cases, close quote. I want to repeat, these people have been put in the hokey, not charged or convicted of insurrection, but charged under a statute clearly intended to deal with, I mean, I can remember when that thing was going through Congress. All the hearings were bankers and former bankers. All right. So if the Supreme Court agrees, so Fisher has taken this case to the Supreme Court. If the Supreme Court agrees that prosecutors have been making improper use of Sarbanes-Oxley, then the convictions of these hundreds of rioters are likely to be voided, and 2 of the 4 counts that Jack Smith has brought against Donald Trump will also have to be tossed out. Okay, so let me put this question another way. For more than 3 years now, the press, the Democrats, and certain Republicans, notably Liz Cheney and Mitt Romney, have been telling us that the events of January 6th represented a direct assault on our democracy itself. Joe Biden just said this all over again in his big campaign kickoff speech at Valley Forge, Pennsylvania, just a few days ago. But the best the Justice Department could do in prosecuting these people who staged this attack on democracy was accuse them of violating some subset of a white-collar statute. So if the Supreme Court says prosecutors use that statute improperly, hundreds of rioters will see their convictions overturned. So,
But by the way, again, you use the word rioter as if they were rightly convicted. The correct way, I think, to put the issue is they were at the Capitol building, and you have to prove that they were rioters. And some of them were, and some of them were not. And so when you use a statute like this, you don't want to prejudge the case by announcing that they were rioters. You want to say, here there were people there. Some of them were taking selfies. Some of them were rioting. Some of them were inducing other people to do it. But it's
they're all there.
But you notice I didn't call them insurrectionists.
Yeah, I know that.
Half a point for that.
That may be a trespasser as opposed to a rioter.
Yes.
Right?
Okay,
right.
so the point I'm trying to make is 2 of the charges against Trump get tossed out.
Yeah.
But hundreds of people, a lot of them are still in jail. People have been in jail for months and months and months for wandering
it's
into...
completely abusive.
Although
but what
most of them pled guilty to this. There were very few actual trials.
Yeah.
Okay, so the Supreme Court it looks to me as if I didn't know the background, I said, this is a very technical matter. How do you use this statute? How are you not permitted to use it? But it's not a technical matter at all. It's right in the middle of our politics.
Yeah.
One party is trying to run on the events of January 6th, and the Supreme Court may be about to say, let them all out of jail. Let all those writers out of jail. How should the court rule? How should they
first,
handle
this is how another way the Biden Justice Department has completely screwed this up. If they believe the things they're saying in public, they should have charged them all with insurrection.
With insurrection
Conspiracy,
and had it
right? Insurrection,
out.
efforts to interfere with the execution of federal law, right? To stop the electoral count. There are suitable charges, but as you said, they're charging them with these kind of ticky-tacky white-collar crime laws.
And that is because they looked at the tapes, they know more about it than we do, they have the FBI informants telling them, and they come to the conclusion, actually, we can't make an insurrection charge stick.
Or they
is
might
that
have
what's
just,
going on? Why did they come up with these cockamamie little charges?
The former DOJ guy, I think what they sat down and said, it would be too hard to have full-blown open trials for all these people, so let's let them plead out to this lesser charge, this white-collar crime law. Doesn't really fit. But in their minds, we're offering them a good deal, and we're going to process these 900 cases. And then I hope, and this is what they did, focus on the leaders, like the Proud Boys. He was convicted of insurrection. He did have a trial because he didn't want to plead out. And so that's the mindset of the prosecutors. But I think they really screwed up because I think in a politically important case like this, where you are saying in public that they did try to overthrow the government, essentially.
Where 3 years later, a lot of people of goodwill are saying, what exactly did happen there?
Well,
Tucker Carlson plays tapes.
That's part of the reason why I think it was actually important to have a full public trial, because a trial also educates the public. You get to see the evidence, you get to see the witnesses, and I think people would have more confidence if a jury made a decision about these January 6 guys, rather than having them all plead out, and then having the biased January 6th congressional committee, and then having Biden at Valley Forge accusing them all of being anti-democratic and calling them.
He speaks sense, no?
John is not always speaks sense, but on this particular occasion,
occasionally,
he does. Not occasionally, but look, I mean,
randomly too.
There's a serious problem here. If these guys pleaded out, and then they weren't convicted, it's not at all clear that it's as easy to set aside a plea bargain as it is to stop a prosecution that's going to take place. Oh, I see. So the question is there. And this is another form of complete abuse that's taking place. It's also, by the way...
Abuse by whom?
By the government.
By the Justice Department.
These people, remember, they were put in jail and held there prior to the time of the settlements and everything. So put yourself in the position of somebody. You know there's a more serious charge that could be made. You have no confidence whatsoever that the government is doing anything right. You plead out to a lesser charge in order to avoid a more serious sentence. I regard that as an abusive process by the government. Then compare this to the number of prosecutions that took place against the deliberate physical violence that happened in both Portland and Seattle that the government prosecuted. As best I can tell, the number of prosecutions that were initiated in those cases was zero.
Zero.
Right? I think that's correct,
As
John.
opposed to hundreds, over 1,000.
That's mostly state prosecutions.
No, I mean, they're attacking federal property and they're wrecking federal things.
That was strangely President Trump's decision not to send in the troops and
but
not to prosecute
sending
them all.
in the troops is not. But the prosecution was made afterwards under this administration. So what happened is when Merrick Garland was asked to testify, I think this is correct.
He's Attorney General by
but
this point?
only
Okay.
was being confirmed. He
But
said,
during
well,
the
this was not a
confirmation
big deal. There were no people there. I mean, so willful destruction of property is no longer an issue when it's the property of the United States. The problem about Merrick Garland is he has been a completely politicized person, thoroughly corrupt in the way in which he approaches these things, with no pretense of any kind of neutrality.
Hold on.
Richard is putting me in the very strange position of defending Merrick Garland.
You just defended Jack Smith and said he's not a hack.
I don't think he's politically corrupt. I think this is just sort of standard. First of all, it is unprecedented. I mean, the January 6th are unprecedented. Trying to figure out how to respond to it with the criminal justice system is hard and difficult.
But they made it difficult.
Well, what they did, which is the mistake, is they kind of used these tools, like from Sarbanes-Oxley. They stitched together all these things from white-collar crime laws or weird voting rights cases that really don't fit.
They're just trying to clear the cases.
Rather than charging insurrection, which is what they really believe happened. They say they believed it happened, and they should have charged it and tried to prove it. I don't think that's corrupt. I think it's just a mistake.
No,
I think it's just a mistake.
I think it's corrupt. And let me explain why.
All right.
What's
You
happened
just
is
made it worse. Thanks a lot.
what happens is we keep talking about the past cases. What was the next thing that was said most recently by Biden? We haven't finished with this. We are now going to give criminal charges against people who may not have been present at the Capitol building on January 6th. We're going after everybody. Well, at this particular point, there's only one explanation for this. The ability of the Biden administration to sort of win on economic issues seems to have failed. And so their entire case is basically going to rest on J6. It's not even going to rest on
Their
abortion.
entire campaign, you mean?
Yes, the whole presidential campaign is going to rest on this. And the only way in which he could make this work is to basically have Merrick Garland bring the prosecutions that he wants to continue this situation.
Okay.
I regard that as corruption.
Hold on one moment, because this brings me to, we've been talking about the Trump-related cases that are in the court or going to be making their way to the Supreme Court. Let me go through. We have more than 80 charges against Trump spread across a number of different cases. We don't have time to start breaking those down, but I want to talk about them if I can. Well, you'll see what I'm trying to do.
Sure.
Again, it requires a setup, but this one is briefer. Item: Manhattan District Attorney Alvin Bragg charges Trump with falsifying business records to disguise a scheme to pay hush money to women. Item: New York Attorney General Letitia James files a civil suit against Trump accusing him of fraudulent reporting the value of a number of his real estate properties, even though bankers have now testified, oh, no, we got our loans back. We consider him a good counterparty in business. Item: Justice Department Special Counsel Jack Smith has charged Trump with 37 felonies in connection with Trump's removal of documents, separate case from what we've been talking about, from documents from the White House when he left office. Item: The District Attorney of Fulton County, Georgia, which includes most of Atlanta, has brought a racketeering case against Trump and more than a dozen others, alleging a conspiracy to steal the 2020 election. Now, listen to political reporter Byron York. Quote: "We all know the political impact of this. Immediately after the first indictment, that is Manhattan DA Alvin Bragg's, immediately after the first indictment, support for Trump in the Republican primary race shot upward. It rose further amid the later indictments and lawsuits. The lawfare campaign against Trump has been relentless, and it will surely provoke continuing reaction in the months to come." Close quote. Okay. It is clear, case after case after case after case, we're now up to, I think the latest count I read was 91 indictments, and I'm talking about cases other than those that we just discussed before the Supreme Court. And the polls indicate that Americans in their millions are looking at this and saying, this is not justice.
Amen,
this
brother.
is politics. And your reaction to that is?
Amen, brother. I regard these cases as scandalous. First of all, let's just take the number, right? What they do is they take these accounts, and you recall I talked about A, B, C, D, and F before.
Yes.
So what happens is there's now one count for sending the check, another count for signing the check, another count for hiring a delivery man to do it. And then when you multiply the cases so that you could then give the heaviest sentence on that, the standard situation in the situation that Bragg was talking about was a $200 fine. He wants 38 years. Of course it's that way. Letitia James is just utterly irresponsible. Everybody in the banking business knows that banks make their own review of these stuff. And everybody also understands that if nobody has lost any money, it's hard to say that anybody has been defrauded. And therefore, it's hard to say that there are a bunch of people out there who really need to be protected by this wonderful woman against the sort of events that will never happen. So she is totally irresponsible.
Trump's lenders were not widows and orphans.
I mean, the whole thing about this is so utterly insidious and so utterly blatantly political.
But what about Jack Smith and the documents at Mar-a-Lago?
What it is that's a potential claim, but compare it to what Hillary Clinton did in real time when she was in office. I would say he did commit some kind of an offense there. I think John would agree, but it's certainly not with the epic proportions that he wants to make of it. Hillary Clinton, you will recall, just to mention it, she had a live server that everybody could poach upon, and she was let go with a hand. She did not know that it was criminal. First of all, that's wrong on fact, and secondly, irrelevant in law. And so she's getting the free pass. He's getting the extra treatment. People can figure out the disparate nature.
Wow, I just heard a phrase I wish I'd known when I was raising my kids.
What?
Wrong on fact and irrelevant in law. John?
That's pretty good.
Thank you.
So first, just as a criminal policy matter, I don't think it's a good idea to allow states to prosecute under state law former presidents, former federal officials, or candidates for office. Because when they're openly political, as the New York and Georgia cases are, you're inviting tit-for-tat retaliation.
Hold on, I just want to grant that. You say the New York cases, Alvin Bragg, Letitia James in New York, Fannie Willis, is her
Georgia.
name? In Georgia. You are saying,
Obviously,
you're agreeing with this is
yeah.
just obvious.
The
that is politically
motivation
motivated.
the motivations are political.
it's
They ran
undoubted.
for office saying they were going to do this.
Go after
They're
Trump.
partisan elected officials, and they did it. The reason why it's a bad idea is because now some red state DA is going to prosecute Hunter Biden and Joe Biden. You open the door to this tit-for-tat prosecution of everybody's officials under state law. I think that's going to be terrible for our political system. It doesn't really advance the cause of criminal justice because you're not really stopping and deterring crime by bringing these cases. But that's different than the two federal cases. I do think that there are grounds for Jack Smith to at least investigate President Trump for. Actually, I don't even think the classified documents were the problem. What he's probably got there is a good obstruction case because you have all this, right, testimony now, President Trump telling people, hide the boxes with my documents, don't cooperate with the FBI. In fact, if Jack Smith really wanted to get a conviction before the election, he should just pursue the obstruction of justice charges of Mar-a-Lago over classified documents. But
he was right to bring those charges? Was that a correct use of prosecutorial discretion?
Prudentially, no. Legally, it's permissible.
Yeah, legally, I think
permissible.
legally, Richard's right. I think he did commit a crime by refusing to cooperate with the FBI, by keeping those documents, although the state of mind is important. But should the Justice Department...
But you've got Hillary Clinton, what
Yeah.
Hillary Clinton did in the background, and then you also got Joe Biden, where classified documents turn up
4
in
different
his,
places,
yes,
his
exactly.
car, his Corvette.
And a suppression of search warrants to find others. Right?
So that's always a question of prosecution is there are people committing crimes. Which ones do you select out to prosecute in court? And I think Richard, he makes a good point. Maybe we shouldn't be going around prosecuting former presidents, former secretaries of states for mishandling classified documents, although we have, right? General Petraeus was prosecuted.
Yes, but that was a very different kind of situation.
All right, boys, so you have teed up here the last question.
God help us.
And this is a question that I'm going to struggle a little bit trying to put it because you both have legal minds, to put it mildly, and you're not going to want to listen to a big floppy open-ended question. You want
We
some
have been
definition.
for a whole hour already.
Well, unless you're stuck and
We
say
love
it.
you. Peter, we love you. Of course we're going to take floppy questions.
Okay, all right. So just a few months before he died at the age of 100, Henry Kissinger gave an interview to the Wall Street Journal, and he said this about the state of this country today, quote, "There's no element of pride and direction and purpose left," close quote. You've both been taught, first of all, Richard's the one who's been talking about history, but I know you're a classical scholar. You both have a vivid sense of history. And in one way or another, what we've been talking about here is the shock to American norms. Trump is the one who's most often accused of it in the press, and Lord knows that Trump does violate one norm after another. But the notion that the legal system should be used against him in a blatantly political way, as you agree, it has been in New York and Georgia at least, if not also in Mar-a-Lago, that Jack Smith, in asking the Supreme Court to hear a case immediately so it could be sped up and introduced into the middle of the political process, there are norms being violated one after the other on both sides here. Now, it feels to me, I mean, you read from Caesar on, and you get the Roman Republic. There's the feeling that the shock that one norm after another is being violated, and they end up in civil war. And it feels as though we've got a serious problem here.
Yeah.
And the question is, can the pieces be put back together.
Not with the current cast of characters. Look, think of who was running for president in 1920. You know, you get Herbert Hoover was considered ran for president. He was the most distinguished public servant of his era, unless it was Charles Evans Hughes, who was at the same time, or Wilson.
These are brilliant, well-read men who are gentlemanly in personal conduct.
William Howard Taft, Theodore Roosevelt, even Franklin Roosevelt was compared. These were all giants compared to the riffraff that we have running for presidents today. And in part, it's because of the primary system, which has the parties pick people who are extreme within the general public, but median to the party. And so you get very weak candidates running very bad situations, because distinguished people will not want to go through this kind of ordeal. And so we were saddled with an unspeakable number of mediocrities, even in the Senate and the House, relative to what it was 50 years ago. Real decline. John may be more optimistic than I am, but this could be a death cycle.
No, I'm much more optimistic.
Okay.
Well, it's a death spiral, but we can refer to it.
But Richard, you name one cause, and it's a fixable cause, and it's the primary system.
Yes.
That didn't exist
Well, it's
before
not the only thing.
about the 1970s.
It is
or so.
also a bunch of woke education and so forth.
Well, okay, now you're opening. I mean,
but
woke
that's a
education,
much-
coarsening of culture with social
Yes,
media,
all
all
of that stuff. But I mean, John wants to be optimistic,
yes.
and he should have the last word.
Yes, no, we always try to end on an upbeat, Richard. That's why you're always next to last. In
No,
these
this is
interviews.
the death gasp, not of the Republic, but of your terrible baby boom generation that's ruined the country. And Joe Biden and Donald Trump are the very last fingertips of the baby boomers trying to hold on to power. And they are, in order to do it, upsetting lots of norms. But I'm actually optimistic in the sense I think our institutions, despite these outrageous efforts by both of them, our institutions are still responding well. Look at what we argued about today. We argued about an effort to stop the electoral count vote on January 6th. We've argued about the misuse of that failed, and we've argued about the misuse of prosecutorial power. But our institutions have handled it. We're not changing our basic rules of democracy, the basic constitutional system. We have responded, and we're still having elections. This is all, to me, just like second order fighting over the rules. But the basic outlines of our political and legal system are still intact, and I think they're going to be after this election. I actually think my hope is after this next election, the baby boomers, Biden and Trump, will leave the stage, and you'll have a new, younger generation of people who I think actually take the Constitution a little more seriously, take the law more seriously.
You'll have Tom Cotton instead of Donald Trump.
No, you'll have
Nikki
Gavin
Haley.
Newsom.
Well, that's what I was about to say. You'll have Gavin Newsom
Nikki
instead.
Haley or Ron DeSantis. I mean, you
Those,
think about
those
the people.
are fine people.
Yeah.
The Republican Party has a better bench than the Democratic Party.
Well, there are impressively educated and well-spoken
Yeah.
Democrats. That's
Well, name one.
well, I speak as a citizen of California, like my friend John Yu here, where one of the infuriating thing about Gavin Newsom is that he's so articulate and so appealing and so self-assured on camera and so thoroughly mistaken on every policy you can
You
mention.
cannot mention anybody dumber on substance than him. You can get close.
But my point is, it'd be a vast
Would you care to defend another
vast-
man here
Yeah,
against
but
Richard?
vast improvement to have, I'll even say Kamala Harris,
No.
Gavin Newsom, Chris Coons, Governor Polis, instead of Joe Biden. All of them would be a
Or John
vast
Fetterman,
improvement.
who's
John Fetterman.
Well,
you
he's
could
a
go
new
there.
hero, right?
Yes, he is. Now that he's
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 sober.
come out of
Out of
whatever
his
his problem
funk.
was, he was recovering
So I
from a
think
stroke. He's
Kamala
well.
so what
Harris,
you-
as a president, is an inconceivable situation. She couldn't even run a campaign.
All right.
But
all
you
right.
have-
I mean, we don't
no,
want to
look,
talk
what you
about
have-
that.
What you have are two people who are consumed with ambition, and the institutional system is responding to them.
Yeah.
And once they leave, I think you have all those people are going to be more responsible, and our institutions won't have to be fighting so hard to prevent the distortion.
You
that
have
they're creating.
dedicated your life at one level or another to
To
the Constitution.
correcting Richard Epstein.
Well, that's a subset. That's a subset of your overall mission here. But you've dedicated your life, both of you, to the Constitution of the United States. Yeah. And you say that after all we've been through in the last decade, you're more impressed by the Constitution.
By the
Yes,
Constitution,
because it
but
has
not the
responded
Constitution.
well.
Well, let me put it this way. John and I are a generation apart. And this
Three
is
generations
Not 3 generations apart. To be precise, we're 24 years apart. Okay?
All right.
A kid you
That's the
over here.
longest generation.
It is a longest
All right.
generation, right? So he is praising everybody in their 50s and dumping on everybody in their 70s and 80s. I'm dumping on both sets of individuals. So I think I'm more capacious and even-handed than he is.
Richard Epstein and John Yoo thanks a lot for I'm not so sure what. Thank you, gentlemen.
Thank you.
For Uncommon Knowledge, the Hoover Institution, and Fox Nation, I'm Peter Robinson.